Let me tell you a real case where someone won a 4 crore arbitral award, yet the High Court stopped the award without asking the other side to deposit even a single rupee. And finally, the Supreme Court had to step in and say, this is not an exceptional case, and the money must be deposited. This judgment is extremely important for everyone dealing with arbitration and commercial disputes. Imagine putting crores of rupees into a business arrangement. The deal collapses, not because of you, but because the government suddenly prohibits the venue from conducting events. You go to arbitration, fight for years, finally win the award, and then when you try to enforce it, the High Court puts an unconditional stay on your award. No deposit, no security, nothing. Your hard-earned award becomes meaningless. That is exactly what happened in this case. This is the story of the Supreme Court judgment in Popular Caterers versus Ameet Mehta and others, decided on 18th November 2025, reported as 2025 INSC 1354. Everything I am narrating is strictly from the judgment itself. Popular Caterers, a partnership firm providing pure vegetarian catering services, entered into a written memorandum of understanding on 25th May 2017 with Maple Leaf Enterprises LLP, whose 5 promoters signed on behalf of the LLP for the purpose of appointing Popular Caterers as the exclusive caterer for events at the Tulip Star Hotel in Juhu. Under this arrangement, Popular Caterers was required to pay an adjustable, interest-free security deposit of 8 crore rupees, of which they paid 4 crore immediately. However, within just 12 days, on the 8th of June 2017, the entire arrangement collapsed because the Mumbai suburban collector issued a notice directing Tulip Star Hotel to stop renting out its premises for any functions or events, making the performance of the Memorandum of Understanding impossible and leading to the dispute between the parties. The reason was that government authorities prohibited Tulip Star Hotel from hosting any functions. A formal notice was issued by the Mumbai suburban collector directing the hotel not to rent out its plot for events. With events stopped, the entire commercial arrangement became unworkable. Popular Caterers had no choice but to invoke arbitration. An arbitrator was appointed by the Bombay High Court on 11 November 2019. After hearings, the arbitrator passed an award on 28 November 2022. The award directed the respondents to jointly and severally repay 4 crore rupees with 9% interest from June 2017. The counterclaim of the LLP was rejected. A corrigendum was issued on 19 December 2022 to correct minor errors. The award debtors challenged the award under Section 34 before the Bombay High Court. Their petitions were admitted, and during this time, they filed interim applications seeking a stay on the award. The High Court granted an unconditional stay, meaning no deposit, no security, nothing. It went deep into the merits and repeatedly said the award looked perverse. This is where Popular Caterers approached the Supreme Court. The Supreme Court examined the entire matter and referred to several important decisions, including Lifestyle Equities, Sepco Electric, Hindustan Construction Company, PAM Developers, and ITD Cementation. It also referred to Section 36, Subsection 3 of the Arbitration Act. The Supreme Court made it very clear that an unconditional stay of a money award is not the norm. Depositing the money is the rule. Unconditional stay is the exception. The court said unconditional stay can be granted only in exceptional situations. These include cases where the decree is egregiously perverse, or where there are patent illegalities, or where the decree is facially untenable, or where some other exceptional ground of the same seriousness exists. In this case, the Supreme Court said none of these exceptional circumstances existed. The opposite party did not even allege fraud or corruption. There was no material to show any extreme illegality. The High Court had gone into the merits prematurely, which is not allowed at the stage of deciding a stay application. The Supreme Court therefore set aside the High Court's order. It directed the respondents to deposit the entire principal amount of 4 crore rupees within 8 weeks with the protonotary and senior master of the Bombay High Court. The court ordered that the amount must be kept in a fixed deposit with auto-renewal. The Supreme Court further clarified that the Section 34 petitions should be heard independently without being influenced by anything in this judgment. It also clarified that the stay of the arbitral award will continue only after the 4 crore rupees is deposited. The Supreme Court's message is simple. There is no automatic stay on arbitral awards. If someone wants a stay, they must satisfy strict conditions. Depositing the award amount is the default rule. Unconditional stay is permitted only in truly exceptional scenarios. This judgment strengthens confidence in arbitration. It ensures that award holders are not left helpless. It also ensures that courts maintain discipline and apply Section 36 correctly. Arbitration awards must be respected unless strong reasons exist to interfere. If you want more Supreme Court judgments explained in a clean, simple, story-based talking format, comment below and let me know which judgment you want next. Thank you for watching and stay connected with Nava Legal for clear and practical legal education.